Um, Look, usually when we talk about, government documents or statutory interpretation, people's eyes kind of start to glaze over.
Oh, yeah,
I
absolutely.
mean, I get it, it sounds super dry, but
Oh,
today we are looking at a stack of documents, social media posts, and petitions coming out of Ellis County, Texas that honestly reads like a suspense thriller.
it really does. And I want to be clear right off the bat here. We are diving into a very specific localized situation in Texas, but
Don't let the geography fool you.
exactly, don't let it fool you. Ellis County here is really a microcosm. The themes we're seeing in these sources, like unchecked government power, the sanctity of the family unit, the absolute necessity of the rule of law, these are completely universal issues.
Okay, so let's sort of set the scene for you listening. We have this group of sources, parents, activists, legal filings, and they are sounding a massive alarm. They aren't just saying, CPS made a mistake.
No, not at all.
They're alleging that the child protection system in this county has basically gone rogue. They claim it's bypassing the law to tear families apart. And they actually have a specific name for it in the documents. They call it rubber stamp justice.
Rubber stamp justice. I mean, it's a heavy accusation, and what makes this deep dive so critical for us to unpack is that we aren't talking about clerical errors.
Right.
We aren't talking about, a caseworker forgetting to file a form on a Friday afternoon. These sources are alleging a systemic, calculated effort to bypass constitutional rights. We are talking about alleged violations of the Fourth Amendment, the 14th Amendment, and this tactical maneuver they refer to as judge shopping.
Yeah, that judge shopping concept. When I first read that in the outline for today, I thought, okay, surely that's an exaggeration. But when we get to the actual timeline later in the show, it is mind-bending.
It's what?
But before we get to the how of all this, we really need to understand the why. Like, what is the actual law supposed to be? Because my understanding was that Texas recently changed the rules to prevent exactly this kind of thing from happening.
You're spot on. To understand the anger that's just radiating from these documents, you have to understand Texas House Bill 567. This was a landmark piece of legislation that passed back in 2021.
Okay.
The Texas legislature looked at their data and realized something deeply disturbing. Way too many children were being removed from their homes for reasons that literally had nothing to do with physical safety.
Right, like poverty issues.
Yeah.
Things like the fridge is empty or the house is messy.
Exactly. Or even marijuana use in isolation. The legislature basically said, enough. They drew a hard line in the sand. HB 567 explicitly states that you cannot remove a child for those reasons alone. They raised the bar significantly.
And the new standard is immediate physical danger.
Immediate physical danger, yes.
That feels incredibly specific. It means the kid is at risk right now, this very second.
Precisely. It was meant to be a shield for families. But, and here's where the sources claim the system has adapted, whenever you build a wall, water tries to find a crack.
Yeah.
The allegation in Ellis County is that caseworkers and courts have found a loophole to get around HB 567.
And what is that loophole they're using?
2 words: lack of insight.
Lack of insight. I mean, that sounds incredibly vague.
It is, and that is exactly the utility of it. Since they can no longer say, your house is messy, so we're taking the kids, the sources claim they've pivoted to this psychological subjectivity. They claim the parent lacks insight into their protective capacities.
Okay, let's unpack this for a second because this feels really slippery. If a caseworker accuses me of something, say, endangering my child, and I say, no, I didn't do that, here's the proof. Am I defending myself? Or am I showing a lack of insight?
That is the Kafkaesque trap the sources are describing. If you agree with them, you're admitting to being a bad parent. If you deny it, well, you lack insight into your problems, which they then use to argue you're a danger to the child. It allows the state to bypass that immediate physical danger standard, which requires hard physical evidence, and replace it with pure speculation about future harm.
So it basically moves the goalposts from what is happening right now to what does this specific caseworker feel might happen later?
Exactly. And that brings us to the specific case study we found in our source material. This is where we move from abstract laws to a real-world nightmare. We have a removal that occurred on October 6, 2025. And the timeline here is, well, it raises some serious questions about what the word emergency actually means.
Yeah, let's look at this. Because the sources claim that CPS was aware of this family throughout the summer of 2025. They had the file open. They were involved. But the children were left in the parents' care for 130 days.
130 days. That is over 4 months.
Okay, I have to play devil's advocate here for a second just to look at all sides. Maybe they were investigating. Maybe they were slowly building a case. Why does the 130 days matter so much to the source's argument?
It matters because of the standard we just discussed. Immediate physical danger. The parent in these documents poses a devastatingly logical question. If my children were in immediate danger, why did you leave them with me for 4 months? You don't leave a child in a burning building for 130 days while you fill out paperwork.
That is a completely fair point.
Mm-hmm.
If you wait 4 months, aren't you implicitly admitting that the kids were actually safe?
That is exactly the argument. If the danger was immediate on October 6th, why wasn't it immediate on June 6th? The source argues that nothing actually changed in that time frame regarding the safety of the home. What changed, allegedly, was the caseworker's decision to pull the trigger.
Now let's talk about that caseworker for a minute. The sources describe this person as young, inexperienced, and without children of their own.
Right, and obviously being young isn't a crime, but the allegation is that this lack of life experience contributed to that heavy reliance on future harm speculation. Instead of looking at the hard fact that the kids had been fine for months, the caseworker allegedly focused on a theoretical risk. But honestly, the 130-day delay is just the appetizer here. The main course in these documents, the thing that really stands out, is the judge shopping.
Okay, judge shopping. This is the part that sounded like a legal thriller to me. We need to break this down for you guys listening because it gets a bit technical, but it's super important. What exactly is judge shopping, and why does it matter so much in this context?
At its core, it is about jurisdiction. Jurisdiction is the authority of a court to hear a case. In Texas, and specifically in this case, the children were already under the umbrella of the legal system due to previous custody orders involving the parents.
Right.
And because of that, a specific court, the 378th District Court, had what is called continuing exclusive jurisdiction, or CEJ.
Okay, let me try to analogize this to make sure I get it and to make it clear for the listener.
It's
like,
cute.
if I have a dispute about my federal taxes, I have to deal with the IRS. The IRS has the jurisdiction.
That's a good start, yeah.
So if I decide I just don't like the IRS, and I take my tax return down to the Department of Motor Vehicles instead, and a clerk at the DMV stamps it approved.
Then that stamp is completely worthless.
Right.
The DMV has no authority over your taxes. It doesn't matter if the clerks find it. It doesn't matter if it has an official seal on it. It is void because the DMV lacks jurisdiction.
Okay, so applying that analogy here.
Right.
The 370th District Court is the IRS. They own the case. They're the only ones who can deal with it.
Correct. Under Texas law, once a court has continuing exclusive jurisdiction, no other court can touch those kids unless the case is formally transferred. It is a strict rule designed to stop parents or the state from running around to different judges until they get the answer they want.
So if CPS wanted to remove these kids, they were legally required to go to the 378th District Court.
Yes, but according to the documents we're looking at, that is not what happened. On October 7, 2025, CPS allegedly bypassed the 378th entirely. They went to a completely different court, county court at law number 1.
The DMV, in our analogy.
Effectively, yes. The source describes this court as a stranger to the children. They had no file. The case literally didn't exist in their system, yet CPS allegedly presented an order to an associate judge in that court, and that judge signed it.
But wait, does it really matter? I mean, I can hear a listener right now saying, okay, so they used the wrong courtroom. Who cares? If the kids needed protection, isn't the paperwork just a formality?
That is a very dangerous way to think about it. Jurisdiction isn't just paperwork. It is the foundation of the entire legal house. If you allow the state to pick and choose which judge they go to, you destroy the impartiality of the justice system. You allow them to find a friendly judge who might rubber stamp a request that the proper judge, the one who actually knows the family's history, might reject out of hand.
Wow. And the sources claim this order was a legal nullity, which sounds like lawyers speak for it never happened.
It means it is void. It has absolutely no legal force. But here is the real kicker. The sources allege that the system knew they messed up. Look at the specific dates in the documents.
Yeah, I'm looking at the timeline now. The removal order was signed by the wrong court, the stranger court, on October 7th.
Right, but the motion to actually transfer the case to that court, that wasn't filed until the next day, October 8th. And the transfer itself wasn't signed until October 10th.
So they took the kids on the 7th based on an authority they didn't officially get until the 10th.
That is the allegation. They put the cart before the horse. And legally, you cannot retroactively fix jurisdiction. You can't break into a house on Monday and then get the search warrant on Thursday. On October 7th, when those children were removed, the county court at Law Number 1 arguably had zero power to authorize it.
Which brings us straight to the Constitution. Because if the piece of paper they waved at the door was void,
Then the entry into the home was an unreasonable seizure.
that is a direct violation of the Fourth Amendment.
Exactly. The Fourth Amendment protects us from the government coming into our homes and taking our property or our children without a valid warrant. If the order is void, there is no warrant. It's just government agents taking children.
That is terrifying. Just the implications of that are huge. But it actually gets worse in these documents.
Yeah.
We have to talk about the trial by ambush claim, because this touches on the 14th Amendment, which is due process.
Due process is basically a fancy term for fair play. It means the government cannot take your rights away in secret. It has to give you notice. It has to tell you, hey, we're suing you and here is why, so you can actually prepare a defense.
And in Texas, there's a specific statutory rule for this, isn't there?
There is Section 262.109 of the Texas Family Code. It says if the state takes your children, they have a non-delegable duty to provide written notice with specific legal warnings by the very next business day.
Non-delegable, meaning they can't pass the buck. They have to do it themselves, did they?
According to the sources, absolutely not. The father claims he was never given this notice. But the smoking gun here, according to the documents, is an admission by the state itself.
Wait, the state actually admitted in writing that they messed up.
Indirectly, yes. The source points to a document filed on November 3rd where the state admits that as of the major adversary hearing on October 17th, they had not even served the father with citation.
Hang on. October 17th was the big hearing to decide if the state gets to keep the kids, right?
Yes.
So the state went into a courtroom to argue to keep this man's children, while admitting in their own files that they hadn't even legally told him he was part of the lawsuit.
That is the claim. Imagine walking into a courtroom. The stakes are the highest they can possibly be, your own children, and you realize the other side is playing by a set of rules where they don't even have to tell you what you're charged with or that you're formally a party to the case. That is what they mean by trial by ambush. It's designed to keep the parent completely off balance, confused, and unable to properly defend themselves.
I can't even imagine the panic of that situation. You're trying to fight for your kids, and the floor is just dropping out from under you. So surely, when they finally got to court, the parent's lawyer stood up and said, "Your Honor, this is insanity. Wrong court, no notice, void order." What actually happened?
The parent did exactly that. They filed a plea to the jurisdiction. They tried to tell the judge, you don't have the authority to hear this case because of the judge shopping we just talked about.
And did the judge listen?
The source says the judge refused to even hear the motion. He wouldn't let the parent's attorney argue it on the record. He just shut it down entirely.
That feels like hitting a brick wall.
It creates a sense of total helplessness for the family. But, and here's where the story takes a truly fascinating turn, there was someone else in the room. The ad litem.
Okay, explain the ad litem for people who don't spend a lot of time in family court.
The ad litem is the attorney appointed to represent the children. In these types of CPS cases, the ad litem is very often aligned with the state. Their job is to protect the child, and often they view the parents as the risk. They are not usually on the parents' team by any stretch.
So usually the ad litem is sitting there nodding along with whatever the caseworker says.
Correct. But in this case, according to the narrative we have, the ad litem went home after that hearing. They reviewed the parents' motion, the exact one the judge refused to hear, and they realized something.
That the parents were right.
That the parents were legally correct. The ad litem realized that the jurisdictional arguments completely held water. So the children's own attorney filed the exact same motion.
Wow. That is a massive plot twist. When the lawyer who is specifically supposed to be protecting the kids says, actually, the state is breaking the law here, that destroys the whole narrative that this is just a crazy, complaining parent.
It validates the entire premise of the source's argument. It suggests that this isn't just about a specific family's so-called lack of insight. It suggests a structural, mechanical breakdown in the legal process. It proves that the judge shopping allegation wasn't just a conspiracy theory. It was real enough for the children's own lawyer to stake their professional reputation on it.
So we have the bypassing of HB 567 with subjective language. We have the alleged judge shopping to find a friendly court. We have the total lack of due process and notice. It really paints a picture of a system that is operating completely outside the boundaries set by the legislature.
And that realization that the system is breaking its own rules has sparked a major response. Which brings us to the task force.
Yeah, let's talk about this task force. Because usually in these stories, the parents just get crushed by the machine. But here, the sources describe a real movement. They aren't just taking it lying down.
They are organizing, and they are being incredibly strategic about how they do it. This isn't just people venting their frustrations on Facebook. They are crowdsourcing data to expose what they explicitly call the caseworker playbook.
The playbook, meaning they are actually comparing notes across different cases.
Exactly. They are tracking specific judges. They are tracking specific guardians ad litem. They are looking for patterns in the system. Like, does this caseworker always use the phrase lack of insight? Does this specific judge always ignore transfer rules? They're building a concrete database of misconduct.
That is so smart. It turns anecdotal evidence into actionable data.
And they are teaching parents how to fight back in real time. I saw mentions in the documents of evidence logs. They are teaching parents that if it isn't written down, it didn't happen. Document every single interaction. Record every conversation where it's legally permissible to do so.
And the most radical part to me was them invoking the Fourth Amendment right at the front door.
That is a profound shift in mindset. We are raised to trust authority figures. If a nice lady from CPS knocks on your door, your instinct is to let them in to clear up the misunderstanding. Show them the house is fine. This task force is teaching parents the exact opposite. They are saying, no. Unless they have a valid warrant signed by a judge with jurisdiction, that door stays closed.
It's deeply tragic that it has come to that point, that parents feel they have to view the child protection system as a threat to be managed rather than a resource to be trusted.
It is tragic, but the source explicitly states their goal. They are reporting these deprivations of rights and declaring that business as usual in Ellis County is over. They are actively trying to drag these proceedings, which usually happen in secret, closed-door courtrooms, out into the light of day.
And that brings us back to a phrase I saw in the source material that really stuck with me as I was prepping for this.
Oh, yeah.
Kidnapped under the color of law.
That is the ultimate indictment, isn't it? Color of law means you are acting with the authority of the badge or the state, but you are violating the very legal rights you are sworn to uphold.
It's terrifying because it flips the entire script. We give the state the power to take children because we assume they will only use it when it's absolutely necessary, when there is that immediate physical danger we talked about at the start.
But if they use that power by skipping the proper court, if they use it by ignoring strict notice requirements, if they use it by relying on vague lack of insight accusations instead of hard evidence, then it isn't protection anymore, it's persecution.
The source alleged that the department and the court treated the Texas Family Code like a suggestion.
And that is the true danger here. Laws like HB 567, constitutional protections like the Fourth Amendment, they aren't suggestions. They are the brakes on the car. They are the only thing stopping the state from having absolute, unchecked power over your family life. If those brakes fail,
Then the car crashes.
every single time, and usually is the children who get hurt the most in the wreck.
We have covered a massive amount of ground today, from the loopholes used to bypass HB 567 to that 130-day delay that really makes you question the definition of an emergency. We walked through the technical machinery of judge shopping, our DMV versus IRS analogy, and the terrifying reality of a trial by ambush.
And we saw a community that has decided to stop waiting for someone else to come in and fix it.
It is a developing story, and one that clearly has a lot of passion and pain behind it. But before we go today, I want to leave you listening with a final thought to mull over on your own.
Let's hear it.
We spend a lot of time in society thinking about how to protect children from bad parents. That is what CPS is for. But if the agencies tasked with enforcing the law are willing to bypass the law to achieve their goals, who protects the families from the state?
And if the law is just a tool the state uses when it's convenient, but ignores when it becomes an obstacle, does the law actually exist? Or is it all just a performance?
That is the question you have to ask. Heavy stuff, but absolutely necessary to understand. Thanks for taking this deep dive with us into Ellis County.
Stay curious and know your rights.